Thank you very much for coming to our third Friday workshop series brought to you by the Berkeley Law New Business Practicum. We provide free legal assistance for folks who can't afford attorneys, which are almost everybody. And so we do come down here every third Friday to try and give you a quick workshop with what you need to know in a certain area of the law. Many entrepreneurs have encounters with the law on an everyday basis. And instead of giving you an hour-long workshop on like contracts, for example, we try and boil it down for you what you need to know in about 15 minutes, okay? But leave lots of time for questions and then have lots of forms that we can pass out here. And as I said, any of these forms we'll have at the end an appendix, sort of a list of all the forms that we brought with us today. And so if you're missing one of those, just shoot me a card or an email and I'll send that out to you, okay? But one thing we wanted to cover for sure for new businesses or any kind of business is contracts. Contracts is something that every business needs to know something about what to do with. So, okay. So here's our agenda for today. First, a few things about why use contracts. I think probably most people in the room know why we use contracts. The minimum steps to creating a contract. And then here's a couple of things that might be really helpful to you is that contracts, well, like this thing here, let's see, like this one here, commercial lease agreement, like about 15 pages here, very intimidating, very intimidating. So what we try and give you is a sense of ways to read contracts, looking for common elements, and then also common kinds of provisions and wording that once you see them, anything that'll help you feel more comfortable with them, that's what we're hoping is that you'll go forward with a sense of confidence when you get a contract of some sort, that you can attack it in some fashion. And then we'll cover little things about how to enforce contracts. Now here are the agreements that we hope all of you have. Maybe check this with what you have right now. We have an independent contractor agreement, an invention assignment, an IP licensing agreement, that's the one I think we ran out of here, commercial lease, a founder's agreement, restricted stock agreement, that would be for sharing equity with in your company for that. Yeah, just take one of each, and if you're missing one of these, just let us know. I think we also brought a term sheet, which is another way of financing your business. It's a beginning document that helps you set up relationships with investors. Promissory note, that's a plain old debt note. Website terms of use and privacy policy. I don't think we had that, Brendan. I don't think I brought that one, so we'll definitely send that. Okay, but generally, just want to let you know this is a general overview of these things, and of course, anytime you're using a particular contract or you're trying to fill in a particular contract, usually a good idea to run it by an attorney before you use it. So we're going to turn over to Kevin to get started on why use contracts. If you would.
That's right.
Deputy Kevin Shute.
So written contracts, a lot of terms to go over. You might be thinking, oh, this is going to increase the friction to get this deal done. Why use in the first place? Well, of course, as an entrepreneur, you're juggling so many different relationships, and it's important to kind of clarify the expectations of both parties. Now, often what happens in early stage businesses and as you mature, you will have these contracts written out between all these different parties and your business. Okay? Founders, workers, capital providers, investors, or anyone who might be extending some kind of credit to you. Of course, the suppliers of your raw material, everything that you need to do and you need to have in order to provide the goods and services of your startup or your company. Insurance, lawyers and insurers always going hand in hand. Certainly, I would always recommend having insurance as provide a bit of a backstop in case any damages occur. Of course, your end consumers. You might not think of every time you enter into an interaction with a customer to be one where you would have a contract laid out between them. And it might be true for certain kinds of quick sales of products. If you're a grocery store and if the customer is buying groceries from you, you wouldn't insist that they sign on to a written agreement with you. But of course, we do have examples of terms of service and privacy policy that you might have in force within your company's website. Right? These do lay out the terms that both parties agree on, and if the consumer violates this by, say, scraping all the data from your website or all of your API endpoints and just attacking your site with millions and millions of hits, that's not okay. You're allowed to ban that consumer from ever reaching your site again. Right? Just one example, of course, the privacy policy certainly more in the news nowadays with the whole Facebook issues. But yeah, certainly important to abide by those policies if you're extending that to your consumers. Now, in terms of why use contracts, essentially on the legal side of things, as lawyers, we're the kind of risk-averse angels on your shoulders, try to push for more certainty and clarity around each of these relationships. Now, initially what happens is that things are very happy, right? You're getting together, starting this business, and it's on very friendly terms. Where contracts would be very useful to have is later on, and perhaps the possibility of disputes arising. Right? And so in times like this, very important to have a contract. You might also ask, like, oh, why would I need a contract with friends and family? Right? These are people who know me, that I've grown up with. I guess I'd say it's not so much that you should be highly skeptical and paranoid of even your blood relatives. Without having to villainize everyone that you interact with, really the contract establishes clear lines of who has agreed to do what, right? And what kinds of risks are on the expectations of risk on each side. And certainly when it comes to future investors who you want to woo or persuade to invest in your business, they'd want to see these kinds of arrangements documented. So in case these more informal relationships sour for whatever reason, they just kind of fall by the wayside, the investor is still assured that, oh, you have a reliable revenue stream to come into your business. That is essentially what they're investing in. Now, in terms of how to make a contract, we do have these three essential elements. That's the kind of classic law school exam kind of components of a contract. Of course, the offer, acceptance, and consideration. I think at this point it'd be useful to offer a scenario here. Bill, yeah, I will sell you this pen for $2. Wow. What do you think about that?
Yeah, $2. Yeah, that sounds good.
All right, there we go. So that is an example of a highly successful sale, but also a valid contract, right? You had this offer. I have offered Bill this pen. He has accepted, and there's this element of consideration, which means an exchange of value between both parties. Right? This
I can bend mode.
Oh, yes. Okay. So that's crucial. Now, kind of rewind. See this? Bill, I will sell you this pen for $2. What do you think about that?
Geez, I can get this. Nope, sorry.
Well, there we go. We don't have acceptance. Therefore, this offer is rejected. One thing to note is that what you see in the law school exam or the bar exam, it's the offer component is referred to as this very fragile kind of element, where it's kind of likened to this caterpillar that can be squashed by the existence of some, what we might say, a counter offer. And so this is next is the scenario here.
Oh, counter. I really needed that pen. Can I now have it for $2?
Too bad. I mean, because you rejected that first offer, that offer has expired. I am no longer bound to have to engage into this contract, enter into this contract, because that initial offer was rejected. Another scenario. Bill, I will sell you this pen for $2.
Oh, wow. So what is this pen? I mean, is it new? Is it used?
Yeah, yes, the finest quills coming from endangered bird species. Ready to...
Gee, I'm gonna have to think about that. I wish so. Yeah. Maybe you give me like 5 more.
Okay. So right there, that was a counter offer where he has suggested that in exchange for 5 additional pens, a pack of 6, and for $2, then that would be another a deal that would be compatible with both of our minds here. However, just the existence of that counter offer does quash the initial offer. So if Bill went back and said like, oh, okay, turns out I think the single pen for $2, I would also accept that. I would have the ability to walk away from the deal as well, because he has offered this counter offer. The initial offer is I'm no longer bound by that initial offer.
And this may seem a little silly, but when you're talking about big deals for like 1,000 widgets or something like that, there's lots of back and forth. Well, I'll take the widgets if you can get them to me by Friday. Well, I'm not sure if I can get them by Friday. you got to watch, is the offer actually mirrored by the acceptance? And if it's not, then there's no deal. And at that point, people can walk away. You just got to be kind of careful, keep track of it. It's a little bit of a shell game about where was the offer and what was the original offer.
That's right. And one thing to note about these counter offers that could quash the initial offer, if the negotiator during this back and forth, they're just asking questions about, say, like, oh, if Bill said, like, oh, Kevin, see, $2 per pen, that's pretty steep. Would you have any flexibility there? What about?
Chippies and Brown.
Yeah. So these questions that are kind of probing about what the supplier is willing to agree with, that would not quash the initial offer. Those are more just kind of questions of what the supplier would be willing to part with. And so without providing this counter offer, with this initial offer, he would still be able to say, like, oh, okay, I accept your initial offer of $2 for one pen, one green pen, totally fine. And at that point, the supplier would be bound to keep with that offer.
What about the element of time?
That's true. That's true.
Mm-hmm.
So in the case of, often what will happen is in these large contracts, there will be terms that state what kind of preconditions have to be satisfied before this contract is enforceable. Typically in these kinds of very quick sale agreements, as soon as the person accepts, payment terms or payment is exchanged for the property immediately. And so they can happen kind of simultaneously. But it is also possible to enter into contracts where the payment is made in installments, and there is kind of a reasonable window of time after which the offer might expire. Usually it'd be up to the merchant, the person who is making this offer, to say when the offer expires.
It is supposed to be for a reasonable period of time, and if it's a perishable item, then that's going to be a short period of time. If it's maybe steel, you could probably have a steel plant. You could probably leave that offer open for a little while.
That's right. And it's also interesting that so also another classic bar exam question: what happens if the supplier? So this is kind of back in the days before instant communication. And so the supplier say, oh, actually, I can't do $2 for one pen. I'll mail you this letter saying, like, oh, remember that initial offer that I sent you? Yeah, I really can't do that. But if Bill had accepted that offer through the mail before I put in that other letter in the mail, telling him about my reneging on the offer or my revocation of the offer, then his sale would still go through, still be bound by that initial offer.
One of the benefits of email.
There you go. Go email. Yes. And so in general, the contract, you can create.
We have a question online, and it is asking if you could read slowly the different forms and the various contracts. Again, yep.
Yes. Well, why don't you say we'll get that at the end?
Oh, yes.
Okay.
Yeah, we'll have a big slide that has those in larger fonts.
Okay, perfect.
And so contracts in general, you can have them as just oral agreements. You don't have to have them in writing. However, under the statute of frauds, there are certain kinds of agreements where you have to have a written agreement in order for it to be enforceable. One of these is the prenup agreements. Another is if one party is paying for another party's debt. This is like a third-party payer. When it comes to interest in real property, so like houses or apartments for greater than 1 year, agreements that cannot be performed within 1 year. So if these are obligations where I promise to do certain work 2 years from now, there's just no kind of physical way for this obligation to be satisfied until greater than 1 year from now. And so that has to be in writing in order for that to be enforced. If Bill really wanted to go to court and sue me over it, you must have had that in writing, otherwise it's just too vague. And then a sale of goods for greater than equal to $500. So those you have to be in writing.
What about a sale of services?
Mm-hmm.
Same thing, 500 or?
500, and then also can the services be completed within a year?
That's right. And so yeah, with operating acceptance, there must be a meeting of the minds. Oh,
sorry, quick question. What if someone misrepresents when you're making that agreement? So let's say they say it's a brand new pen, but you use it and you realize the pen runs out very quickly, for example. It wasn't brand new and they misstated the facts. What can you do then?
Ooh, interesting idea. Well, that's where we get into something called warranties. So for example, when Kevin gave me this pen up here, when he showed it to me, that created a warranty that it is supposed to act like a pen. So it wouldn't work. If it doesn't work, then he's actually violated the warranty in showing me this pen. There's another kind of warranty, by the way, you should know about, and that is.
So this is the warranty for fitness for a particular purpose.
Yes. So I say, is this erasable? One time I had one of these erasable boards here, and I used permanent markers instead. So I want to make sure next time, is this a permanent marker, or is this something that? And you'll say, oh no, it's the kind that wipes off. Okay, but if it turns out later it wasn't, then he would be liable because he knows that I need it for a particular purpose, and we had a communication about that, and then that created the warranty.
If they're not willing to refund you, then you can take that to court and, okay.
And so this often might get a company in trouble for perhaps an overeager salesperson who really wants to please a potential customer. It might overpromise about what the goods can actually deliver. And at that point, because they have knowledge of this particular purpose that the customer did want this thing to satisfy, by saying that the product will do that, they have created this warranty.
But then, going back to the last thing, that if that still possibly would require writing if the thing that was in question, is subject to go back to last slide, was subject to one of these different things too. But the warranty itself can be oral. I see that too. All right, so let's go back. Maybe consideration. Maybe go on to consideration.
Oh, sure, yeah. Let's see, consideration.
Yeah.
In general, it can be kind of for any amount. It can be as low as $1. Essentially, a court is not going to armchair quarterback and police people from being terrible negotiators. They're fine as long as there's some kind of value being exchanged. When it comes to value, when it comes to past acts, don't count. This refers to if something was already done. So if I said something like, I'm a bodyguard and I pushed Bill out of the way as an oncoming car was about to strike him. After that, I wouldn't be able to sue him in court and say like, hey, you owe me money for this kind of implicit agreement of me saving your life, therefore you owe me lots of money, right? That's how these things go. I've already performed that act, therefore I can't really enforce this this attempt of saying that, oh, I've already done this for you, therefore you need to give me some kind of value.
Similarly, with the past duty, he had a duty to push me out of the way, and so it's not like we created a contract in that kind of situation. So.
That's right. So that would come into play if Bill hired me as a bodyguard, and that was part of my job description. I have to push him out of the way. And if I actually do that, I can't say like, hey, I did this huge thing for you. You got to bump up my pay. That would not count as additional consideration then.
If you entered into an agreement with someone to provide a product or a service, and you didn't have a contract, and then after the fact, both of you want to really nail down the terms of like maybe how it's going to be serviced or warranty or whatever, but the money's already exchanged hands, the product is already exchanged hands, is that contract going to be valid since it's based on a past act?
Good question there. We've had definitely a number of people sort of memorialize things afterward, and so I think what the parties, or what the court would do in that situation would be to say that there was a meeting of the minds that this agreement that was maybe faulty before could be formalized in some fashion if the two parties agree. The problem is if they don't agree.
Well, but I mean, if they agree, but that will be a valid contract.
Once they, we probably would recommend that you backdate it to the date that the thing actually happened, because that's when the exchange should have occurred over a written agreement of some sort. Is that something?
Yeah, I think so. And if there are kind of uneven obligations for one party, we probably recommend at least building in some kind of consideration. It could be $1, $1 for 3 years of service or repair and maintenance.
We also had a contract recently, for example, that said we get to change, one side of the contract gets to change the contract whenever they want to. Okay. Now it's a little different than saying, okay, you're going to provide me services as described in attachment A, and I get to change attachment A if it changes, I need more or maybe less or something like that. That's a little different. You are agreeing upon a certain term that one party can adjust it a certain way. But if a contract says, one side just gets to change it at any point, then the sense is that's what we refer to as an illusory contract, because there isn't a meeting of the minds in that situation. Yeah, it's just, so watch that. So watch putting in an agreement too much power on one side can create the possibility that a court would just say, this isn't even an agreement here.
And so, yeah, also a big part of this is specificity of what exactly is being exchanged by a certain time frame. It's probably one of the minimal amounts of information a court would need to even enforce a contract, because this meeting of the minds kind of suggests that there is some kind of arrangement that the parties have come to, and without, if it's too fuzzy, like, oh, I will help you with your scholarship essays sometime in the future, and you'll give me some money in the future. Yeah, that's pretty wishy-washy.
So a little bit about how to read contracts. Okay, so we got some very intense looking contracts here, guys, but there are, what you should know is that there are 5 common concerns in a contract that you should look for. And that's the way you would start, is I would look, for example, at money. I would say, what does the contract say about money here? And not just how much, but how is it paid, who pays first, when does that happen? I would also look at risk. I would say, like in a landlord-tenant contract, for example. We're going to show you one in a second to give you an example. But so in a landlord-tenant contract situation, yeah, there's a sharing of risk in that situation. The landlord's worried that you're in there and you're going to mess up the place and run away and not get, and they can't get paid, so they have you give a security deposit. So it's a sharing of risk. If something then goes wrong, then the tenant is on risk that we're going to withhold your security deposit. So risk is some point that also goes with control. So in many ways, in that landlord-tenant situation, the landlord is saying, okay, I will give you the benefit of the doubt, you can have the place, but I get to inspect it at the end, and if something's wrong, then I get to get my security deposit back. So usually control goes with risk, is the idea. But you can manage that in the contract, of course. Then there's this thing referred to as standards. And why do I put that in? Standards is the way that sometimes people try and fill in things in the contract as though they sort of understand each other's side on the thing. So for example, in the landlord-tenant context, usually, I don't know if you guys have been renting at some point, but it says at the end of the rental, you must leave the place. Do you know what it's called? What is it that you have to, what condition do you have to leave it in? Anybody here know that? It's called broom clean. You have to leave it broom clean. Okay. What does broom clean mean? It's maybe you go over with a broom, I suppose that's one thing. But the idea is you might want to look and see if there are any of these terms in there that need to be further refined, just so there's no, so like for example, in a landlord-tenant contract, remain, you have to not disturb your neighbors. Well, what does disturb mean? They don't like you, or does that mean sound levels or other things like that? So I would be on vigilant notice in a contract for anything that has like words like reasonable or things that need to be defined further, because that's ripe for a place for dispute. But no contract can really get away without having some amount of everybody understanding what certain terms mean. And then of course the beginning and end games. So for example, in the lease example here, you think of the beginning of the term of the lease, and you think of what might happen if somebody held over. Okay, if somebody went beyond the term of the lease, you want to know that at the beginning of the lease, somebody has to give you their security deposit. Okay, and usually the giving of that security deposit or the giving of the first month's rent, that's going to be the consideration that terms that the contract has actually begun. But then it may say that you have to give me that before you move in. So maybe the date of moving in is not the beginning of the contract. The actual beginning of the contract is when you exchange the consideration, first month's rent. So I think I gave you the general things for a rental agreement. I would start, what I would do is I would go through one of these agreements if you're wanting to use it and just look, just put M next to money or risk next to that or something like that to, again, mark it up a little bit. It makes it more accessible there. Now I'm going to give you something else that also is in contracts, a kind of, how would I say it, language that's being used that should not intimidate you, okay? Representations. This is a fact that is critical to the contract, okay? So, a used car example, the amount of mileage that the car has is a critical fact in buying it. right? So a used car has 50,000 miles on it. Now, if you wanted to, most of these agreements will also have a warranty. A warranty is a fact that is backed up by a promise. So in this, if I use this example, this is a good example too, but if I took this further, I might say the used car has 50,000 miles on it. If somehow that's not correct, then you get to take, $1,000 off the price for every 10,000 that's off or something like that. That would be a warranty. Okay. And similarly here, this car is in good working condition. However, if it breaks down in the next 90 days, you can void the sale. That's another fact with a backup promise. Okay. So look for something like that in a contract. Covenants are just simply promises. I agree to sell them the car for $10,000, or Kevin will give me the pen for $2 or something like that. That covenants are all over in here. They're just promises there. One of the critical parts of it is promises can be set up in order. So that means that a certain promise has to be fulfilled before another promise comes along. So yeah, I will give you the keys. I will give you the keys to the car and title once you give me the money. All right. And if you don't give me the money, then it doesn't trigger my promise to do anything until you give me the money. Okay. So once you see these kinds of things in there, so I might even mark up as you go along, okay, that's a promise. Okay, that's a warranty there. Or, okay, so maybe this is the one thing you might want to do with an agreement is put the promises in order. You say, okay, I don't have to do anything until this happens, and then it triggers my obligation to fulfill my promise. So once you look at those, and once you look at these, the contracts start looking kind of similar, actually. And then you can look at the rest of the stuff that is maybe a little hard to understand, how, vesting goes over time with stock or stuff like that. But remember, like a vesting arrangement, we're all talking about money. Here's a good example, okay? So let's say I was saying to you, okay, come work in my company. I will give you stock over a period of time. To see if you're doing a good job, and then if I don't think you're doing a good job, don't hit these milestones, you don't get the stock. Okay. Well, there's money in that. The risk is I'm taking a risk that you're not going to perform. You're taking a risk that you're not going to be paid in some fashion. You have the control over it because you are the one who's performing. So in many ways, you're going to be the one who decides whether I have to give you the stock or not. And so standards for something like this, for example, I wouldn't want us to say to you, well, work for me for a little while and then you get your stock. No, I would say, let's nail that down. It's usually a 1-year cliff, meaning you have to do a good job for 1 year. If you hit these milestones in the first year, then you start vesting over a 3-year period after that. Every month you get 136. So that's where I would fill that out. Okay, does that give you some ideas there? Okay, and so hopefully these agreements that we got for you here, these things will start looking a little familiar to you, things that will look kind of similar going forward. Now, just a couple other things you should know, and then we'll get you to enforcement at this point. There's a few other things at the end of every contract. We used to have a little cartoon up here that would have these two attorneys looking at it and saying, well, I want to look at this contract. I'm not going to sign until I see the fine print here. Well, that's actually a misnomer because the boilerplate, meaning the stuff at the end of the contract, everybody agrees about this stuff. So it's not like you're going to have a term in there that says, well, everything we said further is not relevant and it's actually this way, and nobody reads it and then suddenly you're screwed. No, that's not the way it goes. Instead, these are things that everybody agrees upon to make sure that the contract works well. Like, for example, what happens if there's a dispute? Okay, we're going to agree in advance that it's going to be potentially mediation or arbitration or something like that. This is a really critical part of it. You are saying in the agreement, and I will tell you that it'll be in every single one of the agreements that you have here. This is the agreement. This is the whole thing. And everything that we talked about, every other agreement we made is now subsumed into this contract. And you can't go then to court and say, well, we orally agreed, we orally agreed. If you have this in your agreement, then a judge is just going to say, sorry, this is what I'm working with here. Modifications, usually each person has to agree. Assignment is kind of important. If you really want to make sure that this contract's being performed by the person you're taking in, we actually have a little workshop where we show the illustration of this. We have Lassie in A Boy and His Dog, and the director is saying, where's my star? And a little Yorkshire Terrier shows up with her trainer, and she says, oh, Lassie, she's having puppies. He assigned the contract to me. So it's like, can you pull somebody out of a burning building? So he realizes he should have put no assignment clause in. All right, just a couple of more. Governing law, usually in California, or working in California, it'll be a California law situation. Let's see, notice. You want to know where to send notice to. This is kind of important here. Most contracts have it. If a certain provision of it is found to be unlawful, then they just cut that one out and the rest of the agreement's still okay. Force majeure from the French. The idea is that if I was going to paint Kevin's house and it burns down before I get to paint it, he can't still enforce his promise with me to have it painted because I don't have anything and it wasn't your fault and it wasn't my fault. So that's usually in a contract. And then this is often important too, which is if somebody lets you got by on something one time, like, oh, you paid a little bit late or something, that doesn't mean you waived a payment provision for all time. All right, well, what if somebody breaks a promise? Here you go, Kev.
Yeah, in terms of these enforcement provisions. Yes. 5 options for enforcing the contract. So quick kind of summary of your options here. Right? First, of course, negotiation. Try to talk it out. Maybe most lawsuits that could be threatened from one party or the other, they're usually settled out of court. Right? The litigation process is incredibly expensive. It's cheaper to go through negotiation. Second option would be mediation. You hire this neutral and a third party, trusted by both sides. There are community resources that you can check out that would provide certain mediation services. And crucially, the mediation itself would not create some binding judgment. It's kind of just you're trusting that this neutral third party would be a kind ear to listen to all the facts and provide their independent opinion. Contrast that with arbitration. This does result in a binding judgment that can be enforced by a court. And so it is oftentimes what a large company would do is to ensure that nothing goes to litigation. Everyone agrees that everything would be settled through arbitration. Of course, you also have the lawsuit option. It's quite expensive. For a small claims court, maybe a better option for things that are less than $10,000. In this particular kind of court, there are actually no lawyers allowed. In contrast to traditional litigation, the lawyer's fees are quite expensive. So yeah, it's going to be a lot cheaper if the claims are small enough to fit in small claims court. And then finally, we have do nothing. Right? You just kind of eat the loss. Often litigation is more trouble than it's worth. But kind of the litigation that sticks through, it's often more driven by emotional attachment, more so than kind of economic rationality. That's also always an option right there. If you have any questions, happy to take questions.
Let's go to the appendix slide. So what we've done now is taken some of these agreements and break them down per slide here. And so if you'd like us to go over any of these here, and the person on the web here, these are the agreements that we have here. And what you should do, by the way, go back to the last slide. If you wouldn't mind, the address line. Yeah. So if for some reason you'd like us to email you any of these, just email one of us and ask for the templates, and we'll send the e-copies along to you. Actually, if we get a sign up, if you can do a sign up for everybody in the room here, we can, if you'd like, we'll create a Google Doc that you can take them out of at any point you want to. Okay. And we'll give permission then for everybody in the Google Doc.
Got it.
All right, well, so let's go to maybe these agreements here. Anybody have any particular questions about any of these guys here? Or any of the other ones?
IP licensing agreement?
Yeah, let's get into that. Yeah. So you want to handle this one?
Sure. Yeah.
Okay.
So often you define this. Okay. In terms of the IP licensing, it could be copyright, trademark, patent, all flavors. Each of them, you can define the scope right? So if you have created some amazing content for your maybe a book, and you'd like to license, or someone would like to license the rights to be able to reproduce it, to sell it for you under their kind of publishing label, what you can do is set geographic, temporal, or exclusivity kind of arrangements for this license. So you give this publisher the right to use your copyright only in North America, right? And you retain the rights for elsewhere. Temporal, it's time bound, so only for X amount of years, then I get to sell as many books as I want within North America. Exclusivity, only they would be allowed, you wouldn't be able to shop around and provide the same kind of license to anyone else. When it comes to warranties, this super important when it comes to the license, the licensor, the person who is licensing their IP to someone else. Because often what will happen is that, I guess these kind of go hand in hand as well with the limitations of liability. If I say that I own the copyright to Mickey Mouse, I better own the copyright to Mickey Mouse. And if any damages arise out of someone claiming that they actually own Mickey Mouse and they have a huge army of lawyers who are ready to sue immediately, then the licensor, the one who said that they actually own the copyright, they would back that up and pay for all the legal costs and the damages that are incurred through this, perhaps this uncertainty about the true owner of that IP.
Actually, where this comes up a lot is, and I would say to you, we've done this in different workshops and stuff. One of the most common places where people need to worry about this is an employee who worked on like some software and now is trying to spin it out into a company, okay? But the problem is that when you work on software for somebody else, they own it if you are their employee. And so if I then said, hey, well, it's my software, I'm going to license it to you, then I've already now created a potential lawsuit for that person there. I better back up that promise with a warranty saying, it is actually mine. But if it is not mine, then I will back you up. And I can't tell you how many workshops we've been at where we said, you know that if you're working for an employer, they own your IP. You will have people in the room going, oh. So just know that that's where a license agreement is going to be very important for you.
I know that there are certain carve-outs that an employee might be able to fall under if they did not use any kind of company resources to create this IP, if they're not on company facilities, if the IP is not directly not related to the either the current or the recently anticipated business areas of the company that they're currently working for, then yes, they probably would be able to fall under that carve-out under California law. However, many employees, they'll kind of think of this wonderful idea, this problem to solve that is very relevant to their position in the company. And unfortunately, that's probably going to fall under that IP invention assignment agreements that they signed with their current employer.
Another one of our agreements. So let's go back to the other agreements and see if anybody has any others they wonder about.
The NDA invention assignment.
Yes,
that's right. So we have two of those. I think we have one for an employee, and then we have one for an independent contractor. So, so similar kind of thing. Just so you know,
It's non-disclosure agreement.
yeah, non-disclosure agreement. I'm sorry. So usually those go hand in hand. The non-disclosure agreements can usually be, you want to make sure that it's either unilateral or mutual. You want to know which one you're using. So if you two just were like thinking you might go into business together or something like that, and you just started talking, you'd probably want a mutual agreement so that you are both under you create this confidential circle between you, but it's not like the responsibilities go just one way. But if you have like a volunteer or somebody who's coming in to do stuff for you, usually it's unilateral. They have an obligation to you not to disclose. And then probably one of the most important things on this is define what is confidential, because there could be a lack of meeting of the minds as to what is a confidential thing that we're sharing with each other. Oh, well, you just heard that on CNN. That's not confidential, or something like that. So anyway, it's important probably to exclude prior stuff that came before. If you created something and you want to make sure you entered into this arrangement and you had created something that you want to make sure you protected, I would even name it in the agreement saying this is not subject the NDA or to our agreement. Now, the invention assignment, usually what that goes with is a cooperation on securing IP rights. So that means if somebody worked up some software for you, you'd say, okay, well, you're going to need to paper that for me. You're going to need to assign it to me on paper. If it's patentable, usually software is not patentable. But if you're, I'm going to try and patent it, then you're going to cooperate with me to say, yes, you know, I'm assigning it to you. I will sign when I need to take this thing. Let's see. Yeah, and again, if they aren't the sole owner, because remember, maybe some people worked on it together, and so you have to get everybody's sign off on it, not just one person's sign off. Give you a quick example of that. Often we have groups of people, probably here, I would say students, who work together on a project. And then like 2 students go, wow, this is really cool. We're going to take this forward. And 2 of them go, I'm going to go, you know, work for the Warriors or something. And then they disappear, but they worked on it for a while. Okay. So what I would do in that situation is I would send them, I would try and think of, okay, how can we get them to assign their rights to us? Well, let me see. And of course, this is starting to take off. And now they hear of it's taking off. Suddenly now you got the Winklevoss problem. And they're saying, oh, but I worked on this so much and all this. So what we tend to do in that situation is if you have some of these stragglers who worked on stuff, send them an independent contractor agreement and say, you know, we all worked on this together. We're just going, you know, we're taking it further. We don't know where it's going to go. But we do appreciate the amount of time you put in on this. How about we pay you, you know, $200 for your time, and we'll treat you as an independent contractor. Why don't you sign this agreement here, which has an invention assignment, which has an NDA on it. And then you get them, then you tie up their rights in that kind of situation. And usually people go along with it unless you're like really.
Literally.
Yes.
Making pizza.
Yeah. So let's see, any of these things that are going on? I would say on the founders agreement, for example, if you're getting people together and doing stuff, I would say, let me see, we have a pen here. We have a pen? No, I mean for this thing.
I'll get it.
Okay. We say on a founders agreement, if you got people trying to figure out what to do, there are really 4 things you need to worry about in a founders agreement. Okay. One is who's putting in capital, who's putting in the money to make this thing go. Oh, let me get back. Oops. There we go. Okay. You want to clarify the deal that you have. Thank you. I think of it in terms of a triangle. Okay, what money is going in? Who's going to put in what kind of money? What are the profit shares that are going to happen, and also potentially the loss shares of that? And then the decision making that's going to happen in this potential venture. These are sometimes called contributions when you see it in an agreement. This is usually called distributions in the agreement, and this is usually called management. Okay, so what you should know is it doesn't have to be related to each other. Many people feel like it has to be related. You put in 50% of the profits, you get 50% of, you put in 50% of money, you get 50% of the profits, and you have a 1/2 decision-making process. But whatever, if it turns out one person's got a brilliant idea, but they don't have any capital, well, it's still okay for them to put nothing in, but they still get a full profit distribution. But let's say that person was brilliant in like the area of marketing. Okay, you might say, okay, well, you don't have to put anything in. You get your full 50% distribution here. But in terms of decision making, we're going to divide the decision making according to expertise, so that when we have a marketing issue, you take the lead on deciding that. And if you're a finance guy, then you make the decisions on the financing. And so you can set it up any way you want, pretty much. And then once you have this thing set up, you can then take it and put it into any kind of legal entity you want to form, an LLC, a corporation, or something like this. There's ways that this agreement is sort of an early stage agreement to create a venture even before you've decided what kind of entity it's there. So that's the founders agreement. Of course, if there's equity that you're starting to generate, if you've created an entity of some sort, there's securities filings that you have to do with that. Anytime you're using equity, you have to make sure that that is well papered, because if you're giving out a piece of the company, that may work really well now, but then when an investor comes in, they're going to want to see what those terms are. Who got the vesting? Does it have vesting in it? Did they earn the vesting?